Ronaldo Hilton, the chairperson-elect of the New York City Loft Board. Welcome to our October 18, 2018 public meeting. Welcome to our October 2018 public meeting. Section 282 of the New York State Multi-Dwelling Law establishes the New York City Loft Board. The board is charged with overseeing the conversion of interim multi-dwelling buildings from commercial and manufacturing spaces to safe, rent-regulated residences that comply with the minimum standards of safety and fire protection stated in Article 7B of the New York State Multi-Dwelling Law. To achieve this goal, the board adjudicates and mediates disputes between owners and tenants, tracks the progress of each building undergoing utilization, and prosecutes parties who violate the Loft law and the Loft Code rules. We first turn to the vote of our minutes from the September 20th public meeting. Are there any corrections or comments to these minutes? Mr. Lynn.
I just had a question for Ms. Balsam with regard to the top paragraph on page 21.
An extra copy?
Page 21. Page 21.
No, I'm sorry. Do you have an extra copy?
Great, yeah, mine.
Okay.
Got it? Okay.
Here's the just read back. I'm sorry.
Any questions?
The discussion was about how, if an extension was granted, when, and in the instance where tenants may have been holding rent, what would be the order of events. And I just couldn't quite figure out what you were saying here.
Say that again.
The way I read it, you're talking about X amount of days from the effective date of the law.
Right.
And I just don't follow.
So the way that the law is drafted, the owner has a certain amount of time from the effective date of the law to do this, to do this, to do this, and all of them start based on that effective date of the law. That's the way the section of law in NPL is drafted. So for our purposes, we would treat the effective date of the law, the date the extension was filed, and then that would be our start date. Because you have to start somewhere, so that's our start date, and then we ping when we're granting, we ping all the deadlines off that date. Does that make sense?
So for the purpose of an extension application, this is your sentence, we count the effective date of the law as the date the application is filed.
Yes. Yes.
So in this instance, if we're going to give a grace period to people who are now way out of date, how would that work out?
So the grace period is just for the filing of the application, and if we granted an extension, it would start on the date of the filing of that application. So in other words, now, people who are out of compliance really can't even file for extensions unless they're new owners or newly covered buildings, right? Or owners with newly covered buildings. So the grace period gives them 30 days, gives those people who can't normally would be foreclosed from filing, it would give them 30 days to file, and if we grant the extension, it would be from the date that they filed that application.
Right. As opposed to the effective date of the law.
Yes.
Right. Okay.
Yeah, because otherwise it wouldn't help at all.
So then, again, in that sense, so for the purpose of an extension application, we count the effective date of the law as the date the application is filed. It's not we're counting the effective date of the law, we're counting the effective date at the start of the extension.
Okay. Yes, that's correct.
All right.
Yes.
Okay. And then I have a couple of small typos that I'll just
Thank you.
Would what you just said say require any correction to minutes?
No, I think he's just clarifying
Just clarifying.
what I did.
Actually, that was mine. We're going to talk about the last one later,
Yeah, this is just minutes piece.
so separate.
Yeah.
This issue I'd like to talk about later, but not related to the minutes.
Right, we just want to clarify for the minutes, if there is something that we need to clarify for the minutes.
Probably not today, but we'll,
Yeah, I was going to
we'll
say,
take
I
another
didn't
pass.
think we were doing anything on extensions today. Today was continuing protected occupancy.
Okay, so when do we?
Next time.
18? After 18?
Okay. I think it would be hard for the average reader to understand what you meant, but maybe that's what you said, so it's accurate in the minutes then.
Yeah, but these minutes can clarify that. So, or,
Indeed, they will, come to think of it, yes. All right, thanks.
okay.
And then I'll just hand over a couple small things.
Thank you, Mr. Delaney. Are there any other comments or corrections to the minutes? Do we have then a motion to accept the minutes? Thank you. Mr. Torres, and is there a second? Mr. Torres. Mr. Rivera.
Mr. Glover?
Yes.
Mr. Barrett?
Yes.
Mr. Welch?
Yes.
Ms. Torres?
Yes.
Mr. Delaney?
Yes.
Chairperson Hudson?
Yes.
6 in favor, 2 absent.
Thank you. And just give me 1 second. We will continue discussing proposed changes to 2 RCNY, to changes to 2-09B of the rules which concern protected occupancy. This also will lead to discussion.
Okay, so I prepared a little PowerPoint, which is very reminiscent of the PowerPoint from last November, but I changed it a little bit because we're not doing a wholesale revision of the rules. So today we're going to talk about protected occupancy, and as we know, protected occupancy, the residential occupant qualified for protection is not actually defined in the law. So what that means is that the legislature left it up to the board to fill in with rulemaking who should be the residential occupant qualified for protection under the law. And our current rule says in B4 that if the prime lessee is protected, no one else is. The current rule says that the prime lessee or sublessor who's not residing there must prove the unit is the primary residence. And the current rule says that the non-prime lessee residential occupants in possession are protected occupants, but it's the cases that say they have to prove primary residence, and this is kind of what we want to reconcile. So in determining how to draft a rule, what rule to draft, we always have to look at the enabling legislation, which in this case is Article 7C of the Multiple Dwelling Law. And the primary purposes of the Loft Law and Article 7C is for residential tenants to assist in paying the cost without being forced to relocate, which implies that they are there, to prevent uncertainty, hardship, and dislocation, which means they're there, and to reduce disputes between landlords and tenants and ease the burdens on the courts, of which there were many cases that were pending at the time the law was enacted. So, interestingly enough, the original Loft Law, Section 286(2)I, which is the specific section that is the enabling piece for our rule, originally the law said, it said nothing about protected occupancy, about primary residence. It said that occupants qualified for protection pursuant to the article shall be entitled to continued occupancy and shall pay the same rent, et cetera, et cetera. That was the end of the section. No mention of primary residence. Then there was a whole series of court cases. I just took one here from the petition for the Dumbo Neighborhood Alliance, but there were many of them that basically said that the term primary residence was familiar to the legislature. If the legislature had wanted it there, then they would have put it in. Since they omitted it, then we can believe that this was a purposeful omission. So what happened after that? Well, the legislature reacted to these cases, and in legal circles, this is huge, right? So somebody brought this to the attention of the legislature, and in 1992, the legislature amends 286, 2i, to put in primary residence, okay? So prior to compliance, blah, 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 residential occupants qualified for protection shall be entitled to continued occupancy, and they add, provided that the unit is their primary residence and shall pay the same rent, etc., etc. So this is a legislative reaction to a series of court cases that is clarifying, theoretically, could have been a little clearer, but clarifying what the legislature intended initially. Because I guess there were a lot of cases where people just were not living there and said that they didn't need to live there. So this is,
I'm sorry, could you just repeat that?
there were cases where people said that they didn't need to live there until after the unit was covered. And in some cases, in at least one case in Manhattan Loft tenants, the argument was that they didn't have to use the unit as a primary residence until the unit was actually legalized and they got a rent-stabilized lease. So I think the courts were none, the legislature was none too happy with that. In support of this idea that it was intentional, I sent you all
Which you didn't give us that.
Manhattan Loft tenants. It's one of the it's one of the cases that I circulated that Mr. Carver had brought to our attention. So yeah, I did actually give it to you. It looks like this without my scroll on it. Okay.
Okay.
You gave it to us last week. I gave it to you, yes, when I sent everything for this meeting.
Okay.
Okay, so in the bill jacket for the 1992 amendment, there were a couple of things that were relevant in terms of what the legislature was thinking. And for those of you that don't know, a bill jacket is a whole bunch of information that was before the legislature at the time that they're thinking about changing the law. So the first thing was the budget report, and in the budget report, it states that the bill provides continued occupancy rights for the tenants of the subject units, provided the unit is the primary residence. And let me just say that the underline under provided is actually in the bill jacket. It's not that I put it in there for emphasis. That's how it reads in the bill jacket. And then it also says that the bill would provide those who lease IMDs the opportunity to continue to live in their units at a regulated rental. Okay, so they're thinking people are there, they're already living there. The purpose of the law is to protect people that are living there and make sure they don't have to leave. The other piece of the bill jacket that I thought lended support was the memorandum in support of the legislation from the Assembly. That states that allows tenants to lawfully remain in their loft residence. If the law expires, tenants occupying these lofts, so again, they're there, right? Could be evicted from their homes. It allows the tenant to remain in their homes. So those are what I thought were the relevant pieces of the legislative history.
That was in 1992.
That was 1992. That was the 1992 amendment to the health law.
The memo in support.
Yes, the bill jacket that I forwarded to you was for that 1992 amendment. If you want to see the one for the original law, I can send that to you. It's a lot longer. It's like 120 pages. So in drafting the rule, what were our goals? We wanted to simplify it certainly plain language. We wanted to delete this problematic except as otherwise provided clause, right? So B1 starts except as otherwise provided. We wanted to get that out. It's caused a lot of confusion. We wanted to try and clarify, and we wanted to come up with a scheme that we thought was comprehensive and fair. People may disagree as to whether or not our proposal is comprehensive and fair. That's fine. The board is welcome to change it in any way they see fit. In terms of the petition from the Dumbo Neighborhood Alliance, so the first proposal keeps that except as otherwise provided hearing clause. So to me, that's terrible. Okay, but there are ways around it. But it ends their proposal for section B1 with, and primary residence shall not be a consideration for determining occupant qualified for protection status hereunder. I don't see how we could possibly pass that given the legislation, which says that they're entitled to continued occupancy if it's their primary residence. So this interpretation basically takes the word continued out of the law. Okay, so the word continued has no meaning whatsoever in that section of law if you interpret it this way. So, you get that one? Right, because the law says continued occupancy if it's their primary residence. Well, what does that mean? So, now you got it, right? So, no, thank you. Much easier than I can do. All right. So what it would read, in essence, based on the interpretation that's proposed by the Dumbo Neighborhood Alliance, they're saying that this section reads that occupants qualified for protection pursuant to this article shall be entitled to occupancy, provided that the unit is their primary residence. Right? Because there's no reason to have the word continued there if primary residence is not important in determining whether or not somebody's protected. So, for those reasons, I reject that argument. In terms of the next section that they propose, this is okay. It's expanding who can be a protected occupant, and I think it's very similar to our proposal. The problem I have with this is that it's eliminating the explicit language about landlord consent. And I think that's very important. The current B2 says landlord consent is not required if people were there on the effective date of the law. So I find it problematic that this proposal is eliminating that. And then in terms of the last section, B4, here.
Go back on that.
Sure.
Yeah,
Okay. So for B2, our current B2 says if somebody was there on the effective date of the law, it doesn't matter whether or not the landlord consented to them being there. Okay? If they were there on the effective date of the law, they can be protected occupants. So people that have been there for longer, to use since Lainey's term, and put in the sweat equity, right? They have this added bonus of it doesn't matter whether the landlord said it was okay. Because normally, the landlord's supposed to know that you're there and consent to your tenancy. But this section that's proposed by the Dumbo Neighborhood Alliance, while it expands the number of people that could be covered, as does our proposal, it eliminates, and I'm not sure why, that kind of extra bonus that tenants who are there on the effective date of the law get.
Can you, in this particular one, you don't show the, like a highlighted red and what's changing?
Well, because the whole thing is changing.
This is their proposal.
Right, this is the Dumbo Neighborhood
not
Alliance's proposal.
I mean, it's not a...
It should all be in red.
It's not a...
Yeah, it would all be in red. But the current rule says, okay, if the residential occupant in possession of a covered residential unit is not the prime lessee, the lack of consent of the landlord to a sublet assignment or subdivision establishing such occupancy does not affect the rights of such occupant to protection under Article 7C. Now that's a tenant-friendly provision, that is being eliminated, and I'm not sure why. Because it's not there. This is their whole,
In their proposal.
yeah.
But we
this is-
haven't eliminated it. It's there.
We have, oh, it's there in our rule, and we want to keep that, staff's proposal keeps that. So one of the problems I have with this proposal is that that language isn't there, and I don't know why. Okay? And then finally, we have the last one, which, interestingly enough, I mean, it tries to clarify a position that B4 is only supposed to apply to out-of-possession prime tenants or sublessors, but it also includes a primary residence requirement, even though the first part said primary residence is irrelevant. So, to me, this is inconsistent, internally inconsistent, and I find that problematic. So, those were our reasons for why we feel that the proposal is not good. Chuck, I know you had asked, Mr. Delaney, I know you had asked last time about the cases on pages 5 to 7, and those are all the Boer Realty and its progeny cases, and the legislature, our position, staff's position is that the legislature enacted the 1992 amendment and put in the primary residence requirement as a result of those cases. So I think that's responsive to the question if it's not putting up.
To a degree.
Okay. All right, so any other questions? Yes.
Can we go back to the last one? I just want to, I understand that this is good. You got the Dumbo submission and now this is your response to it. So
Right.
we're not accepting anything wholesale right at this moment. We're
No.
studying it.
Yes.
So I have a question then about the last slide. If you could just go over why it's inconsistent, what it's inconsistent with?
So the first section that they propose says primary residence shall not be consideration for determining occupant qualified for protection. And then that's B1, and then in B4, they put back a primary residence requirement for some people. So I sort of think you can't have it both ways. Either it isn't or it is. And if it is, it should be for everybody, not just for a certain subclass of people.
Right. Okay, thank you. And I had another question. I liked how you were going over the purpose of what we're doing. I just had a question when you talk about continued, where is it talk about continued?
That's 286.2I. Shall be entitled to continued occupancy, provided that the unit is their primary residence.
Okay, I just have a question about that. If you're interpreting that continued occupancy as a way to lead into the primary residence,
Right.
we also had this little thing last time we met where, and we were looking at a case that we voted on where a tenant left for 3 months, but construction took 11 months. So they were dislocated and they were not currently living there during construction.
That's the residence.
But they were already protected, and it was their primary residence, they just couldn't live there during.
So continued occupancy, like the purpose of the law is to prevent dislocation and continued occupancy, but we're saying construction savers may need to get out. Right? That's a dislocation that can happen for a year or more, to tenants. And so I'm just wondering about holding that as continued occupancy so strongly in primary residency, because there's other examples of where you're not, we're going a little against the purpose of the law, if we're dislocating someone for a year.
Yeah, I don't think a dislocation, I don't think a dislocation for construction is considered in any way not the residence anymore. I think you're just a necessity.
Yeah, but what I'm seeing is that the landlord, there's one particular case where they just arbitrarily say construction will take 4 weeks. But the reality in the other case we looked at, you could be displaced for 11 months, 12 months more than that. And that is like
It's more valid. Because tenants don't usually relocate. It's very rare occurrence. Very rarely do tenants relocate during construction. The case we had on the last calendar was a very rare occurrence. I can't think of many instances where tenants actually are out of possession for 11 months while construction is going on.
But I think that the point here is, the issue that's before us is how do we determine who gets protected under the law? The issue that you're talking about is once they're protected, what happens if they're dislocated?
What happens if what?
If they're dislocated due to the construction. And I agree with you that one of the purposes of the law is to prevent dislocation, and it is something that we talk about when we do the narrative statements, but that's not what this is about. Does that make sense?
yeah, I just feel like we're hanging so much weight on the word continue as something that means like the person's sitting there, like not moving in that apartment, that there, that there's lots of wiggle room there. We talked the last time someone's in a band and they're touring, or someone has family in South America and they're down there for 6 months. Like people have lifestyles
Right.
that don't keep them glued into their apartments, so the continued, it gets back to a definition, I guess, of what is primary.
What is a primary residence?
So
Right.
what you're saying is that you could be a primary resident,
Can you
not
take
live
a-
there, and
Take
not,
my,
I want to be a primary resident and not live there 6 months a year. Is that what you're saying?
Yes.
Yes.
and
Well, I'm just
that,
like-
this is going to be, as the court said in Morgan versus Duncan, this is going to be a case-by-case analysis. Are they gone 6 months for work? Are they gone 6 months because whatever? Are they gone 6 months for the construction? I mean, it's going to be a case-by-case analysis.
So you think that if this came up again, it would go back into the courts to decide whether somebody, let's say we're out of residency for 7 months, and the landlord says, no, you don't live here anymore. Could this then go back into one of the courts again and have another decision come up that we wouldn't necessarily confirm?
So if we found that somebody who's on a routine basis absent from the unit for 7 months of the year, but we the Loft board, found that it's still their primary residence, I guess the owner certainly could challenge that in court in an Article 78. Is that what you're asking, or are you asking whether or not?
Yeah.
Yes.
And if the judge found for the landlord, what would we then do?
We would appeal. And if the appellate division found it, then we would probably have to incorporate that decision into our cases. And if similar circumstances presented themselves, I assume we would have to rule against the tenant. It depends on what our basis was for saying that being absent 7 months of the year is okay. I mean, we had people, we had somebody who was in the Peace Corps, we had somebody who was teaching in Michigan, we had somebody who regularly traveled back and forth to work to Europe for work. So, people do go away and come back, and I think that's one of the reasons that we staff are advocating for a more flexible standard than the Housing Court 183-day standard. I think we, as the Loft board, have to look at a whole different set of circumstances than somebody who's in a rent-stabilized apartment. It's just not the same.
One second, I just want to follow up. There's some, I know, like in federal laws that protects like veterans who are not, who are active duty service and so on, and that could be Is that something similar to what we're trying to do here? To have protected instances where people are not physically present, that could still change the fact that still remains their private residence, right? And that's what we're trying to accomplish, right?
Right.
And I don't see how you could ever say a person who is dislocated for construction purposes, right, is in any way excluded from that place remaining their private residence.
It's the same thing with a property. I mean, obviously, you're vacated, right? You're no longer living there, but you still have a right to take up residence in that unit when the vacate's lifted. I mean,
Yeah, I guess I'm just trying to make a point. If we're upholding the law, the purpose of the law, well, we want to be considerate of dislocation in whatever form.
right.
And our definition, if we're hanging on as continued, like making that loose enough that it allows for a normal lifestyle, so you're not a prisoner to the continued.
Right. No, we should.
Yeah.
I appreciate you putting together that summary because it kind of makes your thinking a little bit clearer. But I'd like to kind of fill in some gaps in the history, if I might.
Sure.
I see.
When the board, oh, by all means. When the board adopted what was then called the regulation on eviction, it created this section that at the time was listed as J1A, which is how it's referred to in the LMLT lawsuit that Mr. Carver has pointed out as something that we should take into consideration. The history is this. When the board adopted, the board set out very limited grounds for eviction. One of them was non-primary residence. The other was nuisance. If you're a drug dealer or some other kind of serious nuisance, you could be evicted. I think that was a J1B or J2, whatever it was at the time. Lower Manhattan Loft tenants sued, taking the position that primary residence should have nothing to do with a tenant's occupancy up until the time that the unit left the loft law and entered in stabilization. And we won on the initial court level in a rather remarkable decision written by Judge Bruce Wright, who agreed that primary residence had nothing to do with the loft law, should be thrown out completely. The case that Mr. Carter distributed is the Court of Appeals decision that basically, and there was a middle stage that I'll skip for the sake of time in front of the appellate division, but basically the Court of Appeals said, no, it's appropriate to have requirement that the unit be your primary residence for continued protection for someone who qualifies for lawful coverage. That is really the way things function for the next 30 years. Primary residence had nothing to do with qualifying for protection. It only had to do with the fact that the owner, if the owner chose, could bring an eviction proceeding, not in front of the loft board, but in court, alleging that the tenant didn't use the unit as her primary residence. And Elliot, to your question, an owner can bring a primary residence suit at any time as to qualify a protected tenant with 100% ironclad proof that the tenant's really living somewhere else, because if the unit's not your primary residence, then that means you must have a primary residence somewhere else. Owners have brought cases against tenants where the amount of evidence they had was rather shaky, but sometimes because of the complicated nature of determining primary residency and various indicia, there have been tenants who probably could have prevailed in court, but they really couldn't afford to fight. So, therefore, Court of Appeals made the final decision that yes, the Loft Board had the right to create a grounds for eviction based on a protected occupant not using the unit as its primary residence. That was settled before the 1992 renewal. In 1992, then a guy who was a counsel for the Assembly by the name of Don Leibowitz said, oh, and by the way, we're going to add that it has to be your primary residence to the law to clarify all of that those court decisions. So in his mind, as the drafter, he didn't provide anything in the bill jacket, but in his mind, he was just stating that yes, the board had the right to require primary residence after a protected occupant is covered by the law. With me so far?
Yes.
Yeah, okay. So our original position of Lower Manhattan Loft tenants, more than 30 years ago, was that primary residence should be a factor at all during the entire time that the unit's governed by the loft law, and only become an issue in stabilization. We lost. What was set up has been the way things have functioned for the last 30 years, and I think it's fair. Now, the other thing to bear in mind is when the Loft Board was created, we did not write rules. What we wrote were called regulations, and they were separate and discrete, and they only became codified as a group in 29 RCNY, Section 29 rules of the City of New York, many years after the regulations were written in the 1980s, the bulk regulations. The regulation at that time, which has now become 2-09, was strictly written to apply to instances where there was a fight over subdivided space or sublet space. There was a case, and I wish I could remember, you knew these people because you were hectoring me at the time. They had basically moved to their summer home in Long Island as a permanent residence for a couple of years because their kid was in school and was having some problems and needed to get out of the New York City school system. They had sublet their loft, and the subtenant lived there through the entire original window period of April 1980 through December 1981. And that subtenant said, I'm clearly the person who should be protected because I lived through during the entire window period. And the Loft Board agreed with that. And the people who had sublet their unit for that entire period of time lost the possession of the loft to the subtenant. All of Section 209 is devoted to separating out subtenant versus prime tenant in a single unit, or subtenant versus, let's make it big, right? Sublessee and sublessor in a single unit, or the case of subdivided spaces where an enterprising tenant rented, say, 5,000 square feet, divided it into 4 separate units, lived in one, and rented out the other 3. They came to be known as mini landlords. And this created a great deal of furor when that rule, which at the time was, when that regulation, which at the time was a separate regulation, had nothing to do with coverage, was written to address, and its original title was Subdivision, Subletting, and Assignment. And it did something unique, and it created great uproar not only between prime tenants and subtenants, but also between owners, because it said, in the case of, I I leased the floor, the lease is in my name, I live in Unit A, and I've got 3 subtenants in Unit B, C, and D, and they're paying me X amount of rent. In fact, I may be making a fortune on the landlord's property. As the prime tenant, I may be paying $500 for the whole floor, and each of those units is paying me $1,000, so I'm coming out ahead at $2,500 a month. I'm not paying any rent. Yes, I could argue that I did make the investment to fixture all those units. It was a whole hullabaloo. And if you read 209 from start to finish, to just discuss those, to just reflect on those issues in an attempt to determine who, in the case of the people who moved their troubled teen to Long Island, gets the unit, or what happens to the subdivided space, 209 makes perfect sense. And the thing that was remarkable is 209 declares that the subtenants of those units were now going to pay the same rent they were paying to that nasty prime tenant directly to the landlord and enter into a privity relationship with the landlord. The subtenants weren't happy because they said, well, why should we be paying so much? We're paying that to him, but really the rent for the whole floor is only this. Why are we paying that? No, the law court said, no, you're going to pay the same rent, but you're going to pay it directly to the landlord. The landlord said, I don't know these people, I don't want these people, I don't know anything about them. I just rented this one guy, I have no idea what he did. It's only been 10 years, but gosh, I'm totally clueless. So all of what is now 209 was originally written to address a specific set of circumstances separate and apart from who's a protected occupant when you apply for coverage. So it's only in the period starting in 2014 where we started to read sections of what's now 209 as defining who should be a protected occupant. I think tenants are satisfied with the notion that the primary residence requirement to continued occupancy is fair. We had a different argument, but we all. But in terms of now, the provisions that we're looking at using primary residence as a test to determine who's a protected occupant, number one, I don't think to address the board's concerns, I don't think it's fair, particularly as it's currently written, because it's looking to a tremendously long period from the window period through a coverage case, that could be 10 years' time. And in rent stabilization, remember, the only way that you bring a primary residence suit is at the end of the lease, the owner says, I'm not going to renew your lease because you're not using the space as a primary residence. So I think drawing on 209 to be perceived as the board's, as an integral part of the board's original scheme of who was covered is wrong. And I think there are ways in which the inherent material arguments, which I'm sure we'll discuss in greater detail, do not apply to loft tenants with regard to how to determine who's a protected occupant. If you think about it in rent stabilization, when I first got my lease to become a rent stabilized tenant, I moved from Iowa, and here's a rent stabilized unit, and I get to rent that unit, and I get a lease. Am I the primary residence? Am I the primary resident of that unit before I sign the lease? Of course not. I live in Iowa. So the notion that primary residence should be a bar toward gaining coverage to loft law protection for someone who meets the criteria listed in the law just makes no sense.
Was that, is 2-09, is that when the cases, when the window closed in 2014, the law staff started looking at protected is 2-09, the primary text. I should
Yes.
use the word primary, but that's like the main
Yes.
text.
209 is
Is there
the
anything
rule
else?
controlling
No, just that.
and the law itself.
What about the section on coverage, page 205?
Sorry, can you?
But that's coverage, that's not protected occupants. 208 is coverage.
208, sorry, 208.
205 is registration.
208 and 209 have to do with how it's
Coverage and
interpreted since
residence.
2014 for protected occupant. Just those two.
205 is registration, 208 is coverage of a building. And it, defines the criteria in 281. And then 209 is where there's a title, and Mr. Denton is correct, it used to be called subletting and other matters. Now it's called,
I have it here.
it's a longer title.
Occupant qualified for
Protection.
privacy protection.
Right, but the-
Validity, subletting, and recovery of subdivided units.
Right. Well, we changed, I think we changed it recently, right after the 2010 amendments to include most of the topics that were part of that section.
Oh, okay, so that's all. So you rewrote the,
No, we just changed the title.
just the title?
Yeah, just the title to reflect what information was part of that section
And added dates, right?
and added dates.
And that's not enough to have a public hearing, that was just a title change in a...
No,
it was a public
There was a public hearing, but that was 2010.
I don't remember when that was exactly, it probably was somewhere around 2013, 2013. I think this when the rules became effective.
It would be great if you don't, if you're okay with providing me the prior to that 2013 change, the way it read, and then after that.
So on the, we've got a lot of issues out there right now, and I really want to address them. But the proposition that primary residency should not be required at all is kind of a bombshell concept. At least
That's not our concept, that's the proposal of the Dunbar Neighborhood Alliance.
okay, so
We are the polar opposite of that.
Okay, but I think that was what Lower Manhattan Loft tenants argued in 1985. They lost and it's settled.
but I think you're actually advocating for that position now in a rule change, is that what you said?
No.
Oh, you have? Okay.
No. I'm simply saying that primary residence should not be something used by the board to determine coverage.
It's not used to determine coverage, it's used to determine protection. It's not the same thing.
Well, on that point, I would like to add that
It's because we've had cases where we covered units but didn't protect people.
yes, and I didn't vote for anything. And in fact, when the board started to revise the rules after the 2010 amendment that added section 281.5, the initial focus and the first 6 months of hearings and argument was over the incompatible use provisions. The board staff created a separate protected occupancy filing, basically in reaction to the provision in 282A, Martha, please correct me if I'm wrong, the provision in 282A that called for a deadline on applications. And that's when the board said, oh, well, you know what, we can now come up with, the staff developed a way to come up with protected occupant filings, which never existed prior to that time. And that was done without any discussion with the board. It was done by the staff. There is no rule that was created to embody that. Instead, the board has looked to 209 to provide a framework for that. The board never had, you were here through this whole period, Elliot, the board never had any discussion about, wow, there's no definition for protected occupant then let's define it.
The other thing I'd like to add is that while 209 did have the title of supplementing other matters, Section B of 209 was titled occupant qualified for possession of a residential unit and protection of Article 7C. That was the title of that subsection B of 209.
And that was the title back when it was a rule. But it was intended to apply to who's qualified when there's a dispute. Because as you can imagine, in those subdividing cases, the prime tenant said, oh, let me get back my loft, and I'll go back to having a 5,000 square foot, $500 a month loft with 4 bathrooms to recover the space. So it was really about who was qualified to keep the space where there was a controversy between prime tenant and subtenant.
Mr. Carpenter.
Well, look, on the issue of the history of the rule, the full history I think is really important to me to kind of understand how the rule as it exists today got there. And I'm wondering if you guys could do some background research on that. That's a very interesting legal argument that is the first time that I'm hearing about it, and I'd like to understand a little bit more about the source of the elevation of the parental. So I want to respond to some of the points that you made, Elaine. And I think, unfortunately, even though I realize you were striving to be clear, I think it created a lot of misunderstanding and I'd say misinformation that I was taking in. So, for example, we have this controversy as to how to define who is a primary resident. Do you use the stabilization standard or something different as you're proposing? And I happen to think that the counting of the days makes some sense, but I think you very much mischaracterized the stabilization law on counting of days. So if you're traveling for work, if you're on vacation, those don't count against you under stabilization. So I feel like you're using that to scare off the board from adopting the stabilization standard, which is actually broader and more flexible than you stated. So let's all just understand the state of our rule at the moment. I believe.
Wait, can I say one thing? Robert, right here, Mr. Treasurer. Can you provide us with just a sheet that has the rent stabilization rules? Just a straight up, like, here's what it is. I've been trying to Google it. It was nice to
We can
know.
provide that if you want. Sorry, John.
So you'll provide it, okay. I mean, I'd rather, I'm not scared of it, I need it to like cross-ref to understand what the more we know, the better.
I'm actually chuckling, not because you've asked me, but because one of the benefits of using stabilization as the standard is that it's been around for 40 years and all these issues have been fleshed out through the case law. So at this point, with the primary residency standard of stabilization having been in existence for 40 years, all the standard is well known in the communities of people who need to know about it.
Yeah, I mean, I think we know that part, it'd be good to just have it in front of us for research.
Yeah, although I'm not sure what that would be, given that, well, I suppose the reg itself is kind of short, so we just only look at that, but realize that there's been 40 years of case law that has delved into all the various holes. Anytime you have a rule, anything written in English, there's always going to be some lack of clarity that the cases ultimately decide. And there's a very long history of case law and stabilization such that that standard is at this point quite well known. So, under the current rule, I believe, if there's no lease in effect, everyone in occupancy on the effective law is protected if it's their primary residence. I mean, I'm probably overstating it.
No, that's actually not correct. If there had been a lease in effect between an owner and somebody who's still there, a prime lessee, then the way that it's defined now, that person's still a prime lessee. I'm not sure that that's a good thing or bad thing, but that's the way it's actually defined now, because it says whether or not a lease is in effect.
Okay, yeah, I was trying to make it even more simple. Let's just pretend that there was never a lease.
Okay,
So then it's just the occupants who are protected.
okay.
It's everybody.
Well, it's the occupants that were there on the effective date of the law,
Right.
right? And occupants who came after the effective date of the law with landlord consent.
Okay. And would the proposed rule change that at all? That scenario, the total absence of a lease?
No.
Okay. So we're really just going to be arguing about what happens if there is a lease in effect or if there ever was a lease in effect. So we have a smaller universe, right? I mean, I should say,
Yes, I would agree with that.
that's the universe that we're talking about.
Yes.
Okay. So the material that you presented was it necessarily geared to that issue as between a lessee and a non-lessee? I mean, was that the point?
It was really geared more toward the primary residence.
Right.
Right, that was
Right.
really where I was going, because that was what we had been discussing, and Chuck had asked about the cases on pages 5 to 7 of the Dunbar Neighborhood Alliance petition, so it was really geared to that.
Okay. So, is there any material that, from the legislative history or from the statute, that supports the proposition that if a lease exists, a lessee and an occupant without, who's not on the lease, should have equal rights to be a protected occupant? I mean, I was looking for that in your presentation, but I realized that wasn't the point. But from the material that you provided, I thought it was really making my point in that the statute and the legislative findings actually use the word tenant. So if a lease exists, one would think that a tenant has priority given the use of the word tenant in the legislative findings, and as I pointed out in the past, one of the subsections of 286 talks about a linkage between protected occupancy and the payment of rent to a landlord. So,
286-2I.
yeah, so from the statute itself, the use of the word tenant and the subsection that I was trying to cite, but you just did, that leads me to believe that the current rule makes some sense in that it is echoing the language in the statute that does give priority to a lessee, when there's a lease. So I guess my question to you is, what's the statutory counterpart to my argument? What's the answer in the statute to the arguments that I'm making from the statute to give a preference to a lessee when a lease exists? I'm not saying that in the absence of a lease we should change anything, but if I'm just talking about the universe of when you have a lessee or, I guess, or a private lessee, just be technical about it.
However, you making a distinction between leasing, tenant, and occupant?
Yeah, yes,
What's this distinction?
yes. Okay, well, a lease is a real thing, right? It conveys a property interest to the lessee on the lease. And under the proposed rule, the existence of the lease, basically the rights of the tenant lease are totally ignored in that equal right to protected occupancy is given to anyone in occupancy, even if they're not on the lease. If they're a couch surfer, if they're a roommate, if they're a lodger or a boarder, terms which appear in the MDL, which I don't know what they mean. But other, so it would be just totally ignoring the conveyance of a property interest that the lease itself represents. And as I already last time, it would be completely wiping out the value of that lease. Now, mind you, the lessee under the lease has real legal obligations to the landlord under the lease. The tenant can be sued by the landlord for failure to follow the lease. Yet the right to protect occupancy is under the proposed rule being given to anyone else who just happens to be there for whatever reason, and maybe valid reasons. But unfortunately, the rule sweeps in everyone, which is why in the past we had asked for some options. There was a common household proposition that seemed, even though I don't support it, it seemed that some board members thought that was kind of a fair compromise. And in terms of, I know your proposal said you were looking for a just and a fair outcome. My impression was that people thought that the common household definition was the most just and fair, but I obviously can't speak for us.
Robert, if you read the reason and the justification for Loft, we got all kinds of information about that. And that is to actually protect people that are loft dwellers, without trying to use the word argument or anything like that. So initially, that's the most important thing, is to try to keep those people that are living in lofts, probably not paying a whole lot of rent, at least at the time in 1982, but to keep them there because it serves the welfare of the city of New York. So while you make a good legal argument, my ongoing position is counter to that.
I appreciate that, but the very legislative findings that you're talking about really do use the word tenant. Your argument is fine for me in the absence of a lease, but if there is a lease, if there is a real property interest, I don't see how legally you get around the existence of that tenancy and the findings themselves themselves uses the word tenant. I mean, that's a fact.
All right, well, prior to 1982, when artists or other people started invading these law buildings in Lower Manhattan, there were hardly any leases.
Okay, so,
I mean, so everybody was living there illegally because there was no protection.
yeah.
I once got into a terrible fight with Mayor Koch at the party. And he just didn't believe that it was right for a certain group of citizens to be able to live in lofts. And fortunately, the commissioner, Bobby Wagner Jr., understood what the law was about and corrected the mayor on this thing, in which case he got very angry and he left. But you see, that was, to me, that's my bottom line, since I've been involved in artist housing, starting in the late 1960s.
I just wanted to add along those lines, I was reading the passage about the lodgers and boarders, and I was just wondering if I could just read the one paragraph, because I'm trying to see how it's in the multiple dwelling model, number
I'm
4.
familiar with it.
Yeah, I wasn't, because I only sat down to read everything in my person. A dwelling is any building or structure or portion thereof which is occupied in whole or in part as the home, residence, or sleeping place of one or more human beings. A family is either a person occupying a dwelling and maintaining a household with not more than 4 boarders, roomers, or lodgers, or 2 or more persons occupying a dwelling, living together and maintaining a common household with not more than 4 boarders, roomers, or lodgers. A boarder, roomer, or lodger residing with a family shall mean a person living within the household who pays a consideration for such residence and does not occupy such space within the household as an incident of employment therein. So, I'm just wondering what we're talking about. I mean, this sees them as human,
It means you can rent your extra bedroom to somebody.
but they are,
And
and
it's called a roomer or lodger.
it calls them humans, but they're border lodgers less than, they don't deserve protection. I'm just wondering like where, then when you take it over to law firm, what we're trying to do, which is, forget for a minute this lease, but the fact that humans are living in a space and our purpose is to not dislocate and to allow for continued occupancy. If they're living there, boarders, roomers, lodgers, and family, how are they not covered? Like, why are they not protected?
Currently, or?
Just, I mean, like, we're trying to get to that
Because the
point
way
where
that the current rule reads, right, it says that if there's a prime lessee and the prime lessee is claiming protected occupancy and they use the unit as a residence, then they are the protected occupant to the exclusion of everyone else, which is one of the reasons that we would like to change the rule. Mr. Carver doesn't want to change the rule.
right. But, so how does that fit in the way it currently is with this multiple dwelling for definitions with borders, lodgers?
So that's a definition of what a dwelling is, right?
So the prime lessee just trumps, like, I like the way it's human, it's talking about human beings, it says human beings, and they're all living in there, and everyone knows they're living in there. And we're trying to protect them for life safety as being on the loft, or trying to help them get to a safe building. But we're not seeing them as humans when it comes to occupants that can stay there. So we're
This
just
has nothing to do, this has nothing to do.
When I say we, it's like the
No,
one
I
we of
understand.
how the law.
Yeah, no, I understand, but this really doesn't have to do with who can stay there or not. Because a prime lessee who has roommates can certainly keep their roommates, right? I mean, I think the issue is for the prime lessee, just to play devil's advocate, and from an owner's standpoint, the issue is for the prime lessee, if the prime lessee doesn't want the roommate there, but the roommate has loft laws, that's going to affect whether or not the prime lessee can evict the roommate. Right? So if we make this change and these people become protected under the law, which is, from staff's perspective, we want to make this change. That is going to have a real life effect out there on human beings.
Is there a way to distinguish, well, I mean, I guess the nuance is the kind of the primary that they have put money and time and just has the boarders in there to help them pay rent versus someone who has roommates that they want to have on there, or a husband and wife or kids or whatever that they want to have on there. There might be like some, position in either direction, but we're trying to cover all the subs, whether it's family, boarder.
So the easiest way to do it is to make it all or nothing, to be perfectly honest. If you start making these distinctions, then we could theoretically run into equal protection arguments and constitutional arguments. If it's everybody, I don't see how you can have that argument, because it's everybody, right? But when you start pulling out groups of people, it could create a lot of legal issues. So, the common household is an interesting idea, but I'm not sure it would pass the law department, and I'm not sure it would pass the courts. So, that is one of the reasons that we backed off from that option.
Mr. Carver, before you speak, I just want to know where the board wants to go. Do we want to, after you speak, do we want to start looking at the rule itself, so we have some discussion here and change it?
No, but what we're talking about, I think, actually affects one line in the red. So I think we are doing it. Yeah.
All right. So then, so from the rest of the board, can we go right after that, right into discussing it?
So I threw out a lot of questions at you. I don't know if you recall them all, but I would like to
Only got one.
hear the responses.
I think we answered a lot of them, but the only section of the law that actually uses the word tenant is the title of 286. Everywhere else in the law, it talks about residential occupant. We have a rule that says that that a tenant is a residential occupant qualified for protection under 7C. I think, as Mr. Barowitz said, if you go back to the original purpose of the loft law, it was to cover as many people as possible, and we've kind of, over the years, I think, lost sight of that, and which is why I think we need a rule change. So, I think that answers most of your questions, but
Well,
perhaps not.
Well, I don't think it adequately answers some of the questions, because I'm looking at the legislative findings in section 280, and I see the word tenant being used in more than one place. So that's a real misstatement
Sorry.
of the statute. And of course, even if the word tenant isn't, and I think tenant and tenancy is actually used in 286, but it certainly talks about a rent-paying relationship between someone and a landlord. So I was really focused, so since I have made legal arguments from the statute as to why a lessee does have an elevated position in the presence of others. And again, I'm just talking about that situation. I'm not challenging the fact that all should be protected in the absence of a lease. You know, what's the statutory counter-argument? I mean, you keep saying that the legislature intended, but once the legislature in the findings is using the word tenant, that easily implies a different status of a tenant as opposed to someone else, and you have the entire body of real property law, right? This is, you know, the existence of a lease is not something to be taken lightly. I mean, that's a real property interest. It's, you know, it's almost, it's tantamount to a deed. I mean, I'm not saying it's the same here, but that's a big leap that you're taking to kind of wipe away a lessee's rights under a lease to actually control the space that they lease.
Well, of course, the lessee has made a conscious decision to take in these additional people, but I would cite, again, going back to Dworkin versus Duncan, which was like the first case that construed the Loft law, where the judge quoted a seminar that was held by Carl Weisbrod, who was the first Loft Board chair, and Joseph Fioca, who was the chief draftsperson on the Loft law. And basically what the court quoted there was that the term residential occupant is elastic and intended to free triers of fact from the structure of more traditional and stable housing arrangements. So in using, they purposely chose occupant, even if they used tenants in places, and I do apologize for my misstatement, right? But even if they use tenants in places, the residential occupant that's qualified for protection, I think they meant to be somebody who is not necessarily a prime lessee.
Yeah, but I mean, as a legal argument, I had asked you for a language from the statute, and you haven't given it probably because there isn't it. But
No, I would argue that the statute uses the term residential occupant qualified for protection. That in and of itself shows that they were trying to protect more than just people who are prime lessees. It's more than tenants, it's not just tenants, it's residential occupants. They used a different term and they used it purposely.
yeah, but that same section assumes that there's a rent-paying relationship between the occupant and the landlord in 286-2I. But a citation from a training seminar that's not a legal argument when you have the statute. I mean,
But you have the drafter of the statute saying, this is why we use this term. I don't know what better legal legislative history you could get than a statement from the drafter of the statute himself.
okay, the drafter of the statute did not vote for the statute. So we are left, we have the statute itself. The statute itself that establishes, that talks about a rent-paying relationship. What? It's the same argument that I'm going to make. A training seminar by someone who didn't vote for the law that's not a basis for statutory interpretation. That's not legal argument. That's kind of silly.
Does it go to intent of the legislation?
No, because we actually have the legislative intent, through the actual words of the statute. So,
Can I ask you a question to you directly? So you're saying if there's no lease, you're open to everyone being covered. But if there's a lease, because you believe in leases, because meaning something, then you favor the permanent.
right, and that's the current state of our rule as interpreted by our current cases, right?
And if the lease is a template commercial lease that the landlord, spent 2 seconds Xeroxing and handed out, that commercial lease for a residential occupancy is still, to you, really important?
I think that's the state of the rule now, right?
Yeah, it doesn't matter what kind of
Yes,
lease it
it
is.
doesn't matter. And,
So any lease trumps not,
sure, and listen, any deed, I mean,
even if it was just like a commercial lease that has nothing to do.
it's a conveyance of a property interest. And listen, almost every deed in New York State is exactly the same template. That's just how these things go, because the courts have construed the language in the template as valid, so everyone uses them, so it's not to run foul. So the fact that there might be a template really isn't an issue. I don't think.
Robert, if there's a ladies and gentlemen agreement without lease, not something written down, you owe me X number of dollars a month. Is that now a lease?
Well, in the absence of a lease, everyone's protected, right? And so there's something called the statute of frauds when it comes to real estate that talks about when something has to be in writing and when it doesn't. So to answer your specific question, I don't
It depends.
know. I don't know. But for purposes of
You owe me money for 2 years, if not, you owe
Yeah.
me money for less than a year, yeah.
But I think for purposes of what we're talking about in the rule change, we're talking about the narrow case where you have a lessee under either an existing lease or an expired lease, right? I mean, that's the subset. And I point out that under the current rule, succession rights exist for
Yes.
those who are related to the lessee, which may in fact be many of the people who are actually in occupancy there.
I think it's broader than just, I have to look at it.
Yeah. I mean, so when we're talking about protecting just the lessee, the succession rights also exist. So there are others who would have rights to protection should the lessee leave. Although I haven't looked at that section since last year, so I just don't recall how it expressed. So I thought that the current rule with the right of succession, when the lessee trumps others, was in itself somewhat of a compromised position, which is why I thought that we didn't need to go any further. But if we're going to go further, I think that the sweeping language of 30 that just pulls everyone in is overreaching in that it just ignores the existence of the lease and basically wipes out the value of property interest of the lessee, which could be very substantial. And there's been no mention of any compensation for that loss.
I mean, I guess to Elliot's point, at least in my architectural, like the way contracts work, if there is a verbal agreement with a client, like I'm in a contract, it's just verbal. So I guess all those humans living in apartment buildings that don't have a lease, they do have in effect a contract contract with their landlord, or they're paying rent, they're, just by the fact that they're in there. So if we looked at it the flip side, if we brought over someone with an expired lease to the bigger definition of everyone is a human living in an apartment has an agreement, you are willing to accept that if you don't have a lease, you deserve these protections.
If there's no lease in existence. That's right, I'll let others speak.
I just wanted to say, so, Robert, please correct me if I'm wrong, but I think the undertones of your argument is basically saying that you think we should just leave it the way that it is, or is that stretching? Is that stretching?
As the owner's rep, yes, that is absolutely my decision, that
So-
stays it is. But if you're going to change it as proposed, it's just too sweeping. I mean, that's my position.
So theoretically, we could actually, for the sake of moving forward, we could actually accept a motion stating that you would like to see us vote to keep it just as it is. Is that a true statement?
That's true. It might be more helpful as a straw poll to see where people stand in terms of all, nothing, or something in the middle. I mean, that's also one way of doing it, just to see where we want to move. We're short some members, but I guess so be it. I mean, we can't do it forever. In terms of, I know Mr. Hernandez had some problems with your proposal. My impression was that he was interested in a compromise position, but I don't know. I can't speak for others. But yeah, I think it would be a good idea to see where people stand, just so that we know where we're going, as opposed to coming back week after week.
We did actually take a vote last time, I believe, to expand the rule. So I think we did vote on that, didn't we?
I think you're right.
Yeah. So I think.
What was that vote?
I think we voted that the board voted that they wanted to expand the rule to protect more people. I believe that was a vote that was done last time. We'll have those minutes next time.
Was that on your specific proposal to actually adopt your proposal?
No.
That was a motion. That was a motion, correct? Wasn't that a motion on the floor?
Yeah.
Yes, that was a motion. I think you made that motion.
No, I didn't.
Who made it? Someone. Mr. Shacker, sorry.
I voted first.
Okay.
Mr. Shacker left during the discussion, so I'm not...
No. There was a motion.
I just saw it.
She just
saw the video, part of it, and I saw his emotion, and the agreement was that the board voted to make changes, that the changes were necessary to the board. What changes weren't, it wasn't specified, but the board, the majority of the board believed that there were changes necessary to the
Okay,
board.
so we should be talking about what changes
Yes.
is what he said. Okay, I didn't realize that it happened. Maybe I'm just putting it out of my mind.
And I mean, that's sort of what I was hinting around to, is that, despite the fact that everything that everyone is saying is extremely beneficial information, somehow or another, we've got to nudge this ball forward into, okay, we agree that we're going to change the rules, and now let's argue the changes as opposed to, so, I mean, again, everything is some really good dialogue and some really good debating, but maybe if we follow the chairman's lead here and get back into this actual document, that we'll be able to move the ball forward in some direction.
I don't want to throw another monkey wrench into this discussion, but in Class A apartments in this city, there are several people, generally that work for airlines, with one lease and with 3 or 4 bedrooms. And people not on those leases that are living there. And sometimes they sleep in the same bedrooms. This goes on in the city all over the place in Class A apartments, where we're not talking about rents of hundreds or a couple of $1,000s. You know, we're talking about very big rents. So now we're making this funny little distinction about, I don't know how many people, you know, small class of people that are trying to keep the city alive here. You know, while at the same time, a lot of stuff is just ignored.
I think I agree that it's a complication that we shouldn't get into, but I should say that I don't expect that all those people have the same rights of occupancy. That's my belief.
So is there a consensus? Well, is there, we could redraft to say that if there is no lease, here's who's covered. Let's leave primary residence off this for the side for a moment. So we could redraft, there isn't a lease, here's who's covered, although I think that's how this whole process is working. And then if there is, and then if there is a lease, then we could tackle that. So that might be a way to approach it.
Yeah, yes.
Yes?
Yes. In fact, I had asked about that last time, and I thought that's where we were headed, and then I got this draft that had no change.
Okay, I didn't realize I was supposed to do that. So,
Okay.
does the board?
That I remember.
Yeah, does the board want us to do that? We can do that. And then,
You need a motion?
I think so. Yes.
Actually, that's not something I would make.
Yeah.
Okay.
Because he doesn't want to change it all, so.
So what is the motion on the floor?
Well, there isn't a motion.
There's no motion. Does someone want to make a motion?
I would be willing to make the motion if Elaine could just say what she just said.
To redraft this draft, okay?
Correct.
Okay, to explicitly state, here's what happens if there is no lease in effect, here's the people that we would cover, and then here's what happens if there is a lease in effect, here's who would be covered.
Okay, so I think we had already voted that we don't want to leave it the way it is. We
Right.
want to move it forward. So I would make a motion that we have the staff draft language for us to look at that says, here's what happens if you have a lease, here's what happens if you don't have a lease. And we would take a look at that.
Or an expired.
I was going to ask about that.
Yes, you know what we're saying.
Well, I think we need guidance for the board as to which way you want us to go.
Similar to what exists now, where an actual lease and an expired lease have to have the same weight, I think.
Yes.
Yes, so
Currently they do.
let's keep that as is, just for the sake of simplicity, and then if we want to get deeper into it in the future, I suppose we can, but let's not veer too far off, just so that we're comparing after and prior.
I'm in total, I'm like in total agreement, but if you expect me to remove all the stuff that you all said and stated in the motion. So
You were getting help, right?
I was keeping coverage, but there's still a lot of information there. Again, we had already voted that we're going to move forward. So we're moving forward, and now we're going to make a motion that we would like to see language from the staff that indicates what would happen in the event of a lease and what would happen in the event that there is no lease.
Yes.
I make that motion, Mr. Chairman.
Does anyone want to second the motion? I have no second.
I'll second it.
Mr. Howard. Mr. Rivera.
Mr. Cover?
Yes.
Mr. Cover?
We have discussion.
Let's have discussion.
I'm sorry, go ahead.
Yeah, are we going to have discussion on the motion?
Go ahead, Jim.
First off, current lease or any lease that is expired,
I believe that's the motion.
a lease that expired in 2007 that was with someone who's not even in the unit anymore?
I think,
No, because then that
No,
person's not there.
No one's a part of the scene.
Oh, we went through, we had a case remanded with the movie guy that wasn't there anymore.
Oh, it's Warner. Something Warner.
Yeah, we denied coverage on that.
I'm trying to understand, would a lease that expired a year ago, or a lease that expired 5 years ago, where the lease says, I'm using this only as an artist studio as permitted by the law, I'm not going to live there?
well, I think if I understand the consensus, and I kept my motion short, but I think we were trying to just move the ball a few inches, and then we were going to tackle that once we moved it a few inches. That was my intention. It wasn't my intention that we were creating a sign seal and delivered one or two options. We were just moving it a couple inches.
I'm just trying to
Okay.
understand.
Okay, I understand, but
Sometimes a couple inches is a lot.
Yeah, I'm wondering about that too, because I don't want it in draft language, I just want it, I would be interested in it researched, like where does it get you? Do you end up making it more convoluted than it already is, which is pretty high bar convoluted? So, before it's drafted into any language that could ever be accepted by anyone, I just want some research, but that doesn't.
that doesn't really help us.
We were thinking of the current state of affairs with regard to the existence.
Microphone?
Yeah, so, I was contemplating the current state of affairs with regard to the existence of a lease either expired or effect. That would be that's the category. So my thinking is to keep the same category, and you guys are instead of changing what happens in that category. The question is how far to expand. Is it take everyone is on the table? Is it common household? Is it possible compromise? Is it something else, or is it no changes? As obviously I would prefer. So in terms of which lease, we're thinking of the current state of affairs of an existing at least in effect or expired with a lessee still there. So we're not suggesting we're changing the categories. The only issue is what happens to that category. That was my understanding of what you're proposing.
Right, and also to what you said, I think we have to see it in the form of a draft so we can say what we don't like and what we do like, because we're in discussion mode now for a few hours based on research and do this and look into that. But if we actually see the language, we can say this is what we don't like about this language. So I would like to see it in the draft. We can always vote the draft down if we don't like it, and say that we want this language changed within the draft. But to just have them research and come back with options, I don't really feel we would get much farther than what we've already gotten. I think we have to see language to say what we do and don't like about it. And I trust the staff to draft language that's close enough that we would be able to look at it and say, this is what we don't like, staff, could you modify this draft this way or that way?
Well, I don't disagree with you, although I don't think we really need a motion to to implement that. And there could be a sense of board to ask the staff to make these changes. But we want to go ahead with that vote, we call for the vote, we can go ahead and do it. I guess that's it, the matter.
It seems to me that the nice thing with the actual vote is that we're definitively moving it to a few inches to the next level. And then if it's questioned at the next meeting or whatever, then you can't go backwards. So that's my liking with the vote. We may be able to do it another way. But just as we sort of already pointed out that we had already decided that we wanted to change it, by voting, you know, to look at some new language, we're voting to move it a few inches, and then we won't be able to go back. So that's my theory of that.
Mr. Levin, do you have something else?
Well, at this particular moment, I would just, as we just witnessed in the last 20 minutes, there was some lack of clarity as to what, if anything, we voted on last meeting. I would just like someone to read me the text of what the proposed motion.
That in the minutes?
Oh, you mean this motion?
Yeah.
Oh, this one? Oh,
Yeah.
My understanding of the motion is for staff to draft another version of this rule, this proposed rule, that makes a distinction as to between people who have no lease whatsoever and people who have or had a lease. And what would happen to the group of people if there's no lease at all, and what happens to the people if there is a current or expired lease.
correct.
Part of the problem I see two big problems with the difficulty where I see two causal factors in the difficulty we're having making progress. The first is that we're really chasing two rabbits at the same time. One question is who's eligible for coverage?
Protection.
Based on who's eligible for coverage or protection?
Protection, please.
Who's eligible for protection based on whether or not there's a lease. And secondly, a much greater concern to me, what they have to do to qualify for that protection in terms of the primary residence requirement. And this still also takes into account that all of this only matters if the board is the one determining this issue, because the landlord is the one that's determining it. Still has the right to register whomever he or she chooses to protect them. So, if we were clear that primary residence was not a test, that we wanted to see a draft where primary residence was not a test for protected occupancy, that would have drawn my vote.
I don't know that I have a problem with that either, but I think we're specifically just talking about lease or no lease or various options for all of these.
And that you want to muddy the water in the same.
The water is already muddy, folks.
Well, I think the staff has some very strong opinions about that.
I think it would be ultra serious.
Yeah, I mean, we have a statute. I mean, it's.
I'm sorry, what would be alternative?
To take primary residency out of protected occupancy.
Actually, I would say I would make the opposite argument that to interpose primary residency as a grounds for coverage could be alternative causes.
Everybody's entitled to their own opinion.
Mr.
But your opinions are the ones that count, because you get to vote.
And my second problem, to be very frank, is this is yet another meeting where we only have 75% of the board present. And to a certain extent, Mr. Carver and I are making opposite arguments. And ultimately, it's the folks in the middle who need to decide this. And it's difficult to have a significant number of meetings where we don't have the benefit of being able to make those arguments to people. I thought, and I'll just pat myself on the back, I thought I did a pretty good job early on summarizing the history of the law, why I think this is a separate rule, why I think my ultra vires argument might trump yours. But the fact that I'm missing a quarter of my audience or more, if a vacant seat is ever filled, makes this kind of a tough process.
Mr. Chairman, with all due respect, we're getting fall a little bit away from the issue in the motion. I had no issue with discussing all these things, these concerns, but I don't want to lose focus.
Right, and I don't want to go there with the tenets of what members in this meeting. So, where are we? Where are we? Is the motion on the table? Is there any discussion on the motion? All right, so we're going to therefore ask Mr. Mayor to poll the board members on the motion.
Mr. Glover?
Yes.
Mr. Barrett?
No.
Mr. Rush?
Yes.
Ms. Torres?
No.
Mr. Delaney?
No.
Chairperson Nelson?
Yes.
3 in favor, 3 against, 2 absent.
So the motion is not passed.
Okay.
We will obviously continue this board meeting. Yes.
I think it's important that, I mean, I agree with Chuck. There are 2 people who are absent here, and which we really need those people on board here to move forward on this. And my vote no was simply,
I'm sorry.
my vote no was simply to confirm that we really have to have a full
But you
day.
didn't, I didn't need your vote no, if Mr. Delaney was going to vote no. But I'm just saying, if we're going to move forward on this rule, if we're going to move forward as a board, then since we don't have any control over absentee board members, we have to do the function of the board with the people present. We cannot be leaning on who's here and who's not, because next month it may be the same thing, and what are we doing? We're wasting the city's time, we're wasting the people's time, and we're wasting your time. So we need to do our job while we're here, and do the job the best that we can with the people here. If we can't act as a board because there's not a quorum, I can understand that. But once we're here, we need to do our jobs.
I just want to say that I support the chairman's statement. I don't think it's really proper that we sit here. We have no idea. I have no idea why some of our colleagues are absent. And I think there's a time and a place for that, but I don't know that. Again, how do we control that? I mean, with all due respect, how do you control it? People have emergencies, people have things that come up in their lives. I'm not sure how you would ever control it. I think we have to put that aside.
I mean, I don't disagree with that. I think nonetheless that we probably have conveyed to the staff enough information for the staff to go on and proceed with some clarification. You know, when I ride along, there are 1, 2, 3, 4, 5 staff members here.
That's the entire staff. The entire legal staff.
Yeah, I like where Elliot's going there. I feel like that discussion was really good. I'm excited to read the minutes because there was a lot to digest there. But the way I would go about the rulemaking, and I've been trying hard, I've been like trying to you, Xerox in mind, just reading it. What I need to see is this issue, like I'm interested what happens if we really segregate out these prime ECs from like the overall mission of like covering more people. It seems like we're creating like a special group instead of the broad law that we wanted.
It's already there. Right? We're not creating it. It's already there. That's how the rule is now.
The prime EC.
Prime SC trust.
Okay.
That's how it's now.
Okay, my experience in my building is different, but I guess you
Well,
said
that's
that
because your landlord,
my landlord
registered
doesn't
people.
care. So my landlord, if you have a landlord fighting you, then it matters.
Correct.
All right.
which Mr. Delaney takes issue with also, that landlord should have that power, I believe, right?
I think everything in 209 doesn't have anything to do with this discussion. I think it's designed only for a limited set of circumstances, as I said earlier, involving subdivided space, sublet space, and questions of the sign.
So then, so let me just ask you this though. How would you decide protected occupancy cases without using 209?
That's an excellent question. And the suggestion I was about to make, one of the things that is stultifying about this process is we're going to come up with something, then we're going to submit it to the law department to see if it flies with the law department. It seems to me we could distill a number of questions where there are very different opinions and submit those questions to the law department to get some prior guidance rather than spend another 2, 3, 4 meetings discussing this, then submit it to the law department and the Department of Proper Language, may versus shall, and wait for it to come back where they may say, oh, that's great, but you can't do that. So I think the stress points are crystal clear. I could, in a week's time, provide you with a list of questions. I bloody well like to see written answers from the law department before we move forward.
Not quite well. I mean, I've never seen, the law department does not make our rules for us. We make it, and then we submit it for review, you know, and also to the mayor's office. We're not in control of the law department, right? So we can't just ask, give them work, basically outside of their normal thing. I'm not, don't quote me there. I'm not saying we can't go that route, but this is not the normal course of how a rulemaking is conducted.
I have reached out to them on certain issues that I felt would be problematic. So, it's not that they haven't been in the loop, but to give them a specific set of questions to answer, I mean, I don't know how they would react and when we would see answers.
You know what, they're going to come back and ask you, what context is this, and what, and so on. So we're never going to do that.
Chuck, I don't think you necessarily have an idea that doesn't have some merit, but I guess I thought this was our law department. And if we come up with something that they don't think is going to pass muster with the city law department, I think they're going to let us know that, you know what, board members, I don't think we should even take this before the law department because I think it's too absurd and I don't think it's going to pass. Now, maybe our legal counsel can tell me I'm thinking wrong, but that's how I'm looking at this, that this is our law department.
No, that was a great comment, thank you. So you have board members, you have a set of lawyers here that are working for you. So it's either you trust them or not. But even if you don't trust them, and they have something drafted, it does have to pass muster with the city's law department. So you don't have to adopt what they ask you. In fact, they can draft what you want. They're just giving you guidance as to what may not pass muster with the law department. So to that extent, we have to do our job as a board in making these rules. It's our job. It's the board's job to do the rules, not the law department's job to tell us how the rules can go before you even send it to them, right? Because they're not even familiar with your processes yet, or as much as you are, I'm sorry. So, and we do have some very smart lawyers at the law department that are familiar with law, but still, this is not their job. They're reviewing laws for all these city agencies, and they're doing other things too. So we have to do our job in forwarding them a product that they can review.
I was just gonna finish when I was mentioning about primacy, the other piece, the primary residence. What would help me is if, last time we had a list that goes to local school, there was a list of things.
That's in the proposed rule.
And rather than just seeing like a final list, I like to cancel possibilities. So when I was asking if you could provide the rent stabilization, like see what they ask, and then we're different than they are, so we're not asking all those things, but just to understand what they ask for primary residence. And then a whole bunch of ideas, and then we can like think about each one carefully and how we want it, with the intention of not dislocating and providing continuous coverage for you. With the intent of the law, like it would help me, rather than just look at a draft. I guess I'm afraid of the draft. I like let's research this together. We have some commonalities of what we're interested in and what the understanding and intent of the law. But when I only see like 6 things, but then I just need more. Like I need more to be able to do my job. Does that make sense? I don't know if how you guys do rulemaking, but I need to see how does rent stabilization define it, how did we do it in the laws before, and along with that, the only other piece of info I mentioned to you, but I didn't mention here in the public is, it's really helpful for me when you did your presentation in 1992, for me to know when these rules have all been modified legislatively and our rules for the city, so that I like the timeline of the history, and you said you were interested in historical information too. It's interesting for me, newcomer on the board, to understand how we got to where we got to, and I love hearing the institutional memory that's alive here within the board, but just if I could just have a timeline of, in 1992, this is what changed, and then there must be a list somewhere of what changed when.
We should probably limit it just to the issues on the table.
Not casework, I'm just talking purely like modifications to the rules.
So that's big also, so it has to be very limited, otherwise it's going to be a full-time job for somebody. It has to be.
Okay, how would we limit it then to,
What's on the table?
or 92 seems a big deal.
209B, we could do 209B, and we could do 286.
Okay,
286, 2R.
that would be helpful. I just feel the more I know, I'm one of those people, the more I know, the more, I fully respect all the lawyers and their research, but for me to make a decision that I'm voting on, I feel an obligation to people to understand what I'm voting on, and I can't understand if it's just handed to me, I have to like see a little more. So that's I'm not even frustrated, I just think this is a normal process, like it's a healthy government process to talk.
I've never seen a process like this. Over 30 years.
I think Mr. Delaney, no.
Sure.
Mr.
No, I was just going to say that, I'm more than happy to agree with Rich and say, if this is my law department, that's great. Now, I know that we had a very interesting piece of research presented to us on the question of retroactivity that was done, I realized, by an intern, and I know that the board's legal department has a lot of work before it. Whereas I assume the law department is just rolling in lawyers, hundreds of them, if not thousands of them. For example, we've gone around several times now on a couple of Mr. Carter's arguments with regard to how and when, and conversely when not, the loft law should be read in paired material with rent control and net stabilization. We've had an argument as to the significance of where 7C uses tenant versus occupant, or residential occupant qualified for protection. And for those of us who aren't attorneys, certainly having some clearer legal opinion from some law department, whether it's, you know, you guys, court counsel, or TaskRabbit, would be helpful in a lot of ways. So,
But that's what you're getting all the time when they speak, right? Isn't that?
well,
isn't that-
and to that extent, I appreciate the degree to which Elaine presented a PowerPoint today that started to kind of codify the thought process in a way that hasn't been put forward quite so much before. But having that, you know, in a 2 or 3 page memo with some reaction to the cases outlined on pages 5 and 7 of the Gunlow Neighborhood Alliance proposal would be even more helpful.
All right, I want to revisit Mr. Barrow's argument that we didn't actually need a motion to the one that failed, correct? I mean, I don't know if, I mean, I'm trying to get, in the interest of having some, you know, some resolution here to do something. We need to have something done. What are we going to come back with next month or next month with respect to the rules, or to these rules that we were discussing today? What are we doing? Are we going to staff want to draft something? Where are we? Are we deadlocked? Or do we just wait up more board members?
Mr. Chairman, I'm concerned that it appears we're going to have 2 consecutive rules meetings where we've had outstanding debate. A tremendous amount of good things brought forward, but maybe I'm wrong, I don't think we've even moved the ball an inch. I think we're in the same place that we were 2 meetings ago, and actually some would probably argue that we're almost in the same place we were 2 meetings before that. I have no knowledge of at what point in time somebody would step in and say, you know, we're not going to continue indefinitely with having 2 meetings a month and this process. I don't know the answer, but I can tell you that I'm concerned that it seems that this could just continue and continue and continue. And at some point in time, I'm thinking that somebody would say, it's not going to continue anymore. You're not making progress. We're going to leave it the way that it is. And so just take those words of caution, and if we as a board can't figure out how to move this ball a few inches at a time towards the goal line, maybe we won't have the opportunity to move the ball at all, and somebody will just say, you know what, we're just going to leave this the way it is. And I don't know. I'm throwing it out there for thought.
Right, and I think that's, I mean, it has the effect of not changing the rule at all, so that's basically where we are. All right. I don't know if I can make.
I would comment to your question that I think the chair has every right to direct the staff to alter the draft in some way without the board voting in favor of it.
That's just the delay. So, on that note, I will direct staff to redraft, these rules to encompass some of those ideas that were brought up in the motion. Perfect. I appreciate the debate. I really do. I mean, I love it. I feel like I'm in Washington somewhere. And I really do feel like I'm Washington because there's nothing getting done in Washington. All right. And, no offense. I'm just trying to be light about this. I really appreciate you guys. But I just also want to thank the staff because they work diligently and hard in getting these things done. And, we hope that by next month, we'll have something better for you to look at with some more of the ideas that you brought up about putting stuff together, and you'll see where they do have a lot of other stuff to do, including cases. And so it's not so easy just to dedicate a lot of time and so much time on what would be a really nice stuff. We don't have the don't have the manpower to do all that kind of stuff, but we're going to take our best shot at it, and we'll see what happens in November with the redraft of this.
Or is that next week?
This is on this particular issue. So this will conclude our October 11, 2018 Loft Board. Oh, I'm sorry.
Your conclusion is so definitive. Before we do that, could we just be clear on, in addition to cases for next week, what portion of the rules we should prepare?
I guess we should go back to extensions, because obviously for the drafting, we need at least 2 weeks, and I don't have 2 weeks.
Thank you.
Before we do that, I just want to remind you, next month we have a presentation for Cheese Flat Forum.
Next week.
Next week we have a presentation Cheese Flat Forum. We encourage as many people as possible to be out, even from the public, to witness the presentation. I think Inspector Roche from the Fire Department has made arrangements for his next of kin and so on to be around to do that. So that will happen next week.
Could we get some backup?
Somewhat.
Backups?
I don't know if it's going to be bagpipes.
Not that normal, but we'll go close. I'll do something.
I'm trying to keep in mind that the room at 22 Reed Street with the public there, because it is a public meeting, and with the staff there and the board there, that would be limited for space. So I'm not thinking we're thinking that one bedroom.
It will be a special meeting, and we'll try to get as many people as possible, and maybe some else. Yes.
Mr. Chairman, I just want to ask if you could just possibly give us a little bit of insight. We are going to be heading into 2 holiday months, November and December. Just give us a little insight what the thoughts are as far as second meetings in those months, et cetera, et cetera.
Okay. I'll just let Mrs. Paulson answer.
So we have one regularly scheduled meeting for November, there's nothing scheduled for December, and we are keeping it that way.
Should we prepare the first, like a sentence or two for the event? And who's going to,
Okay, so there was this resolution that we signed, and that will be read out, but that will be presented to the to next of kin. I'm hoping that the actual chair will be here to make that presentation, and even though that's not yet included, but as much as possible we'll have a photo op, and that's probably I'm not sure if someone want to make it. Are you saying we should have a speech?
I just want to know, I could imagine it would like be more meaningful if we each said a sentence or two about why.
Okay.
Sort of, I don't know, Chuck, you guys knew him for years. I don't know. I didn't know him, but do you? feel the need to say anything? Or is it just the,
It was actually Chuck's motion. Maybe if Chuck wanted to do something on behalf of the board.
I'll give it some thought.
Yes, thank you. Okay, I think just one person. Thank you, appreciate it. Okay, this will conclude our October 11th, 2018 Loft Board meeting. Our next public meeting will be held at 22 Reed Street, first floor, the conference room on October 18th. That's next Thursday, 2 p.m. That's next door. Board members, please sign and hand in your attendance sheets. Thank you very much.